Welcome to today's lecture on the mechanics of succession. Our discussion on the mechanics of succession today centers on how a person's property is transferred at death. While there are different ways to approach teaching this material, I find that it is best to break it down into steps. I will start by giving you an overview of each step, and then we will discuss each component presented here in more detail. Step number 1 is to identify whether the property is classified as either probate property or non-probate property. When we say property is probate property, what we mean is that it's processed by a probate court, and that probate court distributes it to the beneficiaries. Unless property meets the definition of non-probate property, which we will discuss, it passes through the probate process. So let's talk about non-probate property. Non-probate property, in contrast, transfers automatically at death without court involvement. Common examples include property held in trust, pay-on-death accounts, life insurance policies, or real estate held in joint tenancy. So if we have a piece of land that's held in joint tenancy, the instrument that creates that joint tenancy is the deed, and we look to that deed to determine who gets the property at the death of the decedent. That property then transfers without the probate court's involvement. Understanding the distinction between probate property and non-probate property is crucial because it determines the applicable procedures, the speed of transfer, and the legal framework for resolving disputes. It is important to note here that the analysis should be done for each piece of property and not for the entire estate. In other words, one decedent can have both probate and non-probate property in their estates. Again here, the point of this lecture today is not to get bogged down in the details quite yet, but to understand the overall organizing structure. Now let's dive a little deeper. Probate property refers to assets that must pass through the probate court system before they can be legally transferred to heirs or beneficiaries. This includes things like real estate, bank accounts, or personal property that are solely owned by the decedent and are not held in a trust or do not have any of the beneficiary designations that we will review shortly. You can think of probate as being the default. If property is titled solely in the decedent's name and there are no beneficiary designations, then it must go through probate. Probate provides legal authority to transfer title, resolve creditor claims, and ensure that the distribution is lawful. Let's consider these functions in a little more depth. Probate transfers title and provides evidence of the transfer of title to the new owners. Probate also protects creditors by providing a procedure for the payment of debts before the property is distributed. Finally, probate distributes the property, distributes the decedent's property to those intended after the decedent's creditors are paid. So the first step is determining whether or not the property is probate property. Let's say we determine that an asset is probate property. The second step to determining what happens to the property requires us to ask, is there a valid will? And does that will name the property in question? If the answer to both of these questions is yes, the will governs. But again, only if it is a valid will and it actually covers the asset in question. If no will exists, or the will doesn't name either generally or specifically the asset in question, we default to what are called intestacy rules, which we will go over in great depth. Intestacy rules are state statutes that help us determine who receives the property in the absence of a will. If a person dies intestate, meaning without a valid will, these state's default laws step in. These intestacy statutes prioritize close relatives like spouses, children, and parents, often in that order. And intestacy rules are meant to capture the decedent's probable intent, or what the legislature believes that most decedents would have wanted. So, absent actual intent, the legislature defaults to this probable intent. So, to summarize, first, we determined whether the property is probate or non-probate property. If it is probate property, the probate court determines whether there is a valid will that covers the property. If there is a valid will that covers the property, the probate court will then look to the will to determine how to distribute that property. If there's no valid will or the will does not cover the property, the probate court looks to the state's intestacy rules to determine who receives the property. Now let's talk a little bit about probate jurisdiction. We previously mentioned that assets subject to probate must go through a probate court. But how do we know which probate court has jurisdiction? For personal property, the beneficiaries are to file in the county where the decedent was domiciled at death. For real property, they must file in the county where the property is located. Now, this division matters when assets are spread across different counties or even different states. So what happens if the decedent is domiciled in a different location than their property? Or what happens if the decedent owns multiple pieces of property with real property located in different counties? If a decedent owned real estate outside of the county or state in which they are domiciled, a second proceeding, an ancillary probate, is often required. This allows the local jurisdiction to oversee the transfer of real property located within its borders. So why do we need ancillary jurisdiction? Why couldn't the real property just be probated in the county that the decedent lived in? It might seem like it's just an additional burden and expense, and perhaps it is. But ancillary jurisdiction serves two important purposes. The first is that it allows local creditors to be properly noticed, so that if there are claims against the property, they can come forward at that time. And if not, then the title can be cleared. The second purpose is that it ensures that proper recording of the transfer takes place, and that the recording is done in the county recorder's office in which the property is located. You might remember back from property law about how important it was to properly record a deed in a chain of title. Now you may be beginning to see why some people want to avoid probate. Many people use estate planning to avoid probate by utilizing vehicles that allow for the classification of all of their property to be non-probate property, which we'll quickly go over some of these vehicles next. Why do people want to avoid probate? Probate can be slow, sometimes taking months or even years. It can be costly, especially if attorney's fees or court costs are high. Finally, probate is a public process, and that can raise some privacy concerns. Avoiding probate can streamline administration and protect family privacy. We'll talk more about how estate planning can help people avoid probate in more detail later on in this course. In contrast to probate property, non-probate assets pass directly to another person or entity at the moment of death, without needing to go through the court system. This happens by operation of law or through a contractual designation, like a named beneficiary. Non-probate transfers are now incredibly common and are often used to reduce legal costs and avoid probate delays. Here are some of the most common types of non-probate property. Inter vivos trusts, which hold assets during the decedent's lifetime and transfer them to the named beneficiaries without court involvement. We'll cover these in the second half of this course in tremendous detail. Then we have pay-on-death contracts, like bank accounts or investment accounts with designated beneficiaries. There are life insurance policies where proceeds go directly to the named beneficiary. And then there are joint tenancies with right of survivorships, where the surviving joint owner automatically receives full title at the death of the joint owner. You You may remember this title from property law. Each of these mechanisms bypasses probate entirely. Let's close with a quick recap. First, we said we need to classify property as either probate or non-probate property. If it is non-probate property, we simply look to the instrument to see who the beneficiary is and distribute the property to them at death. If it is probate property, we distribute the probate property either under a valid will, or if there is no will, then through intestacy rules. We need to make sure to file in the proper jurisdiction based on domicile or real estate location. We need to utilize ancillary proceedings if needed to clear property title across multiple jurisdictions, or if the property is located in a jurisdiction that is different than the jurisdiction of domicile.